rise for appeals to come on.
Good morning. Please be seated. We're here today in the matter of the oral argument for Sedona Oak Creek Canyon, or not Oak Creek Canyon, sorry, Sedona Oak Creek Airport Authority, Inc. v. Dakota Territory Tours, ACC. Our case number 1CA-CV 20-0158. Each side is allocated 20 minutes. I think you know that. Appellant, if you wish to reserve some of your time for rebuttal, you can do so, but we leave it up to you to keep track. I don't know if we flipped the clock, so your time should be on this side for you over here, and your time, even though it says appellee or appellant, it's the ones in front of you are the ones that are keeping your time. Is that right? Oh, can't we flip it so that they can see them easier?
Right, that's how they can see it.
Oh, okay. All right. Well, hopefully one of those clocks is yours and you can keep track of it.
The one that's counting,
it's going down, that's yours.
the
That's
one
yours,
that's
right.
counting down is yours.
Thank you. We conferenced your case this morning. We are familiar with the record and your arguments and your briefs, so keep that in mind when you're presenting your case. This matter will be recorded. I think we're live streaming for the thousands and thousands of people that will be watching. But we'll also post it on YouTube later. You can go back and review our work and your work if you want. I don't think there's anything else I need to tell the parties. And with that, Mr. Abney, you may begin.
May I take off the...
Yes, you can both take off your masks. If you're comfortable, you can leave it on if you're comfortable with those two as well.
and I understand from your very capable clerk I'm supposed to sit?
That's preferable because we can
Okay.
hear you better since the mic's down there, yes.
All right. Well, it's an interesting case. I was up till midnight trying to figure out what to say, and as usual, I don't have an idea. But the one main point is...
You were busy yesterday, weren't you?
No.
No, last week it was you were busy upstairs.
Well, a while ago. I have a argument this afternoon at the Ninth Circuit by video, so
Okay.
I think my brain has been thoroughly fried. But in any event, I think one of the main issues is this right to jury trial. My client demanded a jury trial, and in an FED action, you have a right to get a jury trial. And I know that, and you probably know from your judicial experience or other experience, that these FED actions are usually very quick. You know, somebody comes in and it's cut and dried. The defendant, if the defendant bothers to show up, says, yeah, I did it, and I need to go, and I need to be evicted, and that's it. But sometimes you get a case more complicated where the defendant demands the jury trial, and it should be given. And in this case, there was a very timely demand. In fact, as I read the record, the demand for jury trial came before the answer was even filed, same day, but they did it in an unusual order, at least according to the timestamps. So there was a right to jury trial, and it wasn't given. That's a substantive right, and I believe that because it wasn't given, we need to start over and get that jury trial. I know it's taken a long time.
How do you reconcile that argument? And I realize you point to the language in the statute that says shall, but we also have language in our Constitution that says shall, and language in other statutes that say shall, and as far as I could tell, the interpretation has been uniform that shall means a right if there are issues for the jury to decide.
Well, sort of.
What about this statute takes it out of that general proposition, or if that general proposition is mistaken, tell me what I'm missing.
Well, the usual rules don't apply in FED actions unless they're specifically incorporated in the FED statutes, and the motion for summary judgment has not been specifically incorporated. And you may say to me, under Rule 9 of the Rules of Procedure for Eviction for Special Action, there is this catch-all H, subpart H, that says other appropriate motions may be made by either party.
I'm sorry, go ahead.
No, I was going to say, before you get to that, I'm going to echo what Judge Morris just asked you. But you have a constitutional right to a jury trial, but we allow summary judgments all the time.
Well, and that ties into this problem here, whether summary judgment is a kind of proceeding that fits with the FED system, and it doesn't given the deadlines that you have. I mean, it talks about other appropriate motions under 9H, but there's nothing appropriate about a motion for summary judgment unless the parties agree to it. But if the parties don't agree to a motion for summary judgment process, it's not appropriate because of the short deadlines that
Mr.
you
Abney,
have for everything.
It would help me if we would bifurcate our discussions here. So, or you can tell me that I'm thinking of this wrongly, but I've viewed your argument as really twofold. One is there's this absolute statutory right to a jury trial.
Right.
Okay. And then second is, even if there isn't an absolute statutory right to a jury trial, the rules of eviction procedure don't contemplate a summary judgment
Right.
proceeding.
Unless the parties would agree to that.
Unless the
I
parties would
suppose that would be all right, but
Yeah, I mean, generally in law, if the parties agree, we'll let just about anything
Yeah.
go. So let's focus on that first one for a second, because as I read your argument, and you write it well, it says shall, and shall means shall, so therefore
Right.
you get a right to a jury trial. But setting aside for summary judgment, I mean, the appropriateness of the procedures used in there, whether that's incorporated. Why does that shall read differently than our constitutional shall and other statutory shalls that we have held and our Supreme Court has held don't preclude non-trial resolutions?
the relevant constitutional shall would be the one that says the right to a jury trial shall remain inviolate. But
And
then
inviolate sounds pretty explicit.
it does,
Yeah.
but it also takes you back into history, tradition, and statutes and common law as to what things you had a right to a jury trial for. Some things by our territorial statutes and moving all the way forward, you've always had this right to a jury trial in FED actions going right back to 1864. So you've got a strong historical tradition that you do have that right for a jury trial. And as far as the shall and the inviolate, it
Hold
really,
on. I don't want you to get too far afield because I want you to focus on what he's really asking.
yes,
And that is, let's assume for the sake of argument that you have a right to a particular jury trial under the Constitution. You do have that right.
Yes.
There's no dispute. But somebody files a motion for summary judgment against you. The court can say, nope, I'm granting the summary judgment motion. Why wouldn't that be the same argument we're saying here?
because summary judgment motions aren't included within the FED scheme. It's
Okay,
not
so-
an appropriate motion because it doesn't fit the time deadlines. I mean, for a motion for summary judgment, what do you get, 30 days for response, 20 days for reply, and then then it'll be scheduled for at least a consideration, and if you're lucky, it'll be scheduled for a hearing.
But
All
you
of that.
recognize that when we were talking about you have an absolute right to a jury trial for the Constitution, we still allow for you to have a summary judgment.
Yes, because under the common law and by historical tradition, you could have motions for summary judgment.
Okay.
But here, you can't have a motion for summary judgment. It's not an appropriate motion because it doesn't fit in any way, shape, or form within the strict deadlines for the jury trial. Was it 5 days for the jury trial and maybe an extension of 10
What
days or
would
so?
the jury decide then in a FED action where there are no contested factual issues? What are we asking a jury to decide?
The right of actual possession, which is the one thing that's provided under 12-1177A. On trial of an action of forcible entry and detainer, the only issue shall be the right of actual possession, and the merits of title shall not be inquired into.
So
The right
then
of
the
actual
jury in this
possession.
case would get into the settlement agreement and to
Right.
the terms of the settlement agreement?
Because that deals with the right of actual possession. It doesn't deal with the title to the property. I mean, after all, I think Yavapai County technically owns it. And
But
then
your
this-
right of actual possession is based upon an argument that you have a right, a property right via the lease and via the settlement agreement.
Yes, the settlement
But
agreement especially.
so that is issues of title. It's
No.
not
that's-
title as ownership, but title to the leasehold.
No, only title in the most amorphous sense you could imagine. What we're talking about here is right of actual possession. Dakota, do you have the right of actual possession? Yes, under the settlement agreement, we have the right of actual possession. It talks about the existing premises, the existing property, the existing lease, non-interrupted use of the premises. All these things give Dakota the right to actual possession unless you've got this request for proposals process done properly.
But
And
again,
it wasn't
if-
done
if-
properly.
If, as a matter of fact, there are no disputed issues as to that, then how can the jury decide something contrary to the facts and to the law?
Okay, if there, if.
And I'm not saying, I'm not asking you to concede that there are no disputed facts and no disputed
Oh,
law,
no,
but
we-
I'm saying in a situation in which we all in the trial court look at it and say, the material facts or the disputes that the parties are alleging are not material, that as a matter of law, there is no right to possession here.
Well,
What would the jury decide?
the FED rules are a little bit different, like everything else, from the rules of summary judgment. It talks about, at the initial appearance, if you demand a jury trial, the court inquires and determines the factual issues to be determined by the jury. And if there's no factual issues, then the matter proceeds to a trial by the judge alone. There's actual trial. It's not a motion for summary judgment, an actual trial, regarding any legal issues. And then it says, may be disposed of by motion or in accordance with these rules as appropriate. The motion that would be appropriate in that circumstance would be one of the ones that's listed in Rule 9. The only two that really count would be a motion for judgment on the pleadings or a motion to dismiss. But motion for summary judgment doesn't fit within that. But the point here
we're
is...
talking to what I had described now. We're moving kind of to the second point, which is...
Well, let me slide back, if I can, to the first point. Talking about the judge inquiring and determining if the factual issues to be determined.
Right.
We've got a whole host of factual issues here. I mean, laid them out in the briefs.
Well, that's the third argument, if whether summary judgment was appropriate. I'm still trying to get through. Statutorily, could there be summary judgment? Now, rule-based, could there be summary judgment?
This is going back to the rules we actually have to deal with in the rules for eviction. It talks about inquiring and determining the factual issues. Are there factual issues there? And yeah, there are factual issues. So you can't derail the trial. There's a lot of factual issues about what this settlement agreement actually means. And the use of the premises, what is the existing property? What does the existing lease cover? Is there this, when it says non-interrupting use of the premises, does that mean you can't do what these guys did, which was to say, okay, we're going to have a request for proposals, but it's not for the property you've leased. It's for another portion of property on the airport. And that's what we're going to have a request for proposals for. And that doesn't fit at all within the settlement agreement when it talks about the existing lease, the existing property, and use of the premises not being interrupted. If Dakota had prevailed and had the accepted a bid, then the bid was it was going to stay in the existing property. And I have uninterrupted use of the existing property, the existing premises. And instead they did this switch.
And I want to give you time to argue that, because that's whether there were material issues of fact to decide. But let's, just for a second, I found this position a little tough to agree. I read Rule 11D as saying, if no factual issues exist, it shall proceed to a trial. Okay?
Right.
Which implies that if there are no factual, if no factual issues exist for the jury to determine, this matter may be disposed of by motion.
Yeah, it would really be a motion to dismiss.
That seems to imply a summary judgment. No, if no factual issues exist, that's a summary judgment standard. And how is that different than Rule 56, which says if there are no material issues of fact, the court can dispose of this by motion?
Well, you just said what the difference was. Material issues of fact as opposed to factual issues. All you have to do is show, we have a factual issue, and the other side may say, well, it's not material. Too bad. It says here, factual issue. It doesn't say material issue, genuine issue, or anything else. It says a factual issue. And identify the factual issue. And I did identify some of the factual issues.
So could a FED defendant say, I'm actually 29, and they think I'm 45, and that's a factual issue for the jury to determine. So we're going to get a trial on this? Even though it's completely irrelevant to the issue of possession.
If it has something to do with the case, I suppose.
Well,
but then that's material.
Well, no, I still think there's a difference there. If you identify, what factual issues do we have here?
Well,
for the jury to determine.
The other side may say, well, that's not
seems to be
material.
materiality to me.
Well, the other side may say that's not material, and then you'd have to take a look at this rule again. It says, well, it says factual issues. And if this is a factual issue, that's, it's got to be relevant to the case, of course.
Well, then if it's relevant, isn't it material?
I think there's a difference between material and relevant. I mean, you could have an issue that's relevant and really doesn't matter a whole lot in the great scheme of things.
Of consequence? Isn't that the definition of relevance?
No. Well, I don't have my dictionary with me, so I can't really tell you
I
on
just
that.
go to the rules of evidence.
All right, I've enjoyed this, but because I do think you need to touch upon the material, or not the materiality, but the facts that are in dispute and how those preclude or give you a right to possession.
Well, the facts that are in dispute is
Unless you disagree, okay.
Okay. The facts that are in dispute, and I laid them out in the opening brief at page 28 and the reply brief at page 17. There's about 15 different ones, but the ones that seem to me to be most important is
The subset of 6 that you identified.
Yeah,
right?
there's
Okay.
there's a set of factual issues there that I set out, about 15 or so, but the most important ones is what is this request for proposal about? Is it about the actual property that Dakota is leasing? And if it succeeds in the request for proposal, it gets to continue with the uninterrupted use of those premises. And that's probably the most important set of factual issues right there. If you determine that one way, Dakota wins 100% because what they did here was to say, okay, we're going to have requests for proposals, great, but it's not for that property. It's for a different property within the airport itself, a different property entirely. And so if Dakota had won, got the proposal, succeeded in the proposal, it would have had to have moved, which would not have given it uninterrupted use of the premises because it's not the same premises.
But how did Dakota keep a right or establish some right, which I think would be implied in your argument, to stay in this exact building for all eternity?
It doesn't. If you had an actual request for proposal that dealt with this actual leasehold property right there, those premises.
Didn't its original lease, or at least original lease as extended, expire 3 years ago?
Well, and then they had a
2017.
dispute about everything, and we came up with a settlement agreement. So
Right.
the settlement agreement controls.
And then
so
they issued an RFP, and does the RFP say, or I don't read the settlement agreement as saying, giving a lot of specifics that the RFP had to provide for this. It just said, an RFP shall issue, and if Dakota's the winner, then they get to stay.
right.
If they lose, they have to vacate the property.
Right, but the property that's being dealt, the property that involves the settlement agreement, what it's all based on is the existing lease of the existing property, not some other property that the airport authority says, well, we're going to do this RFP for this other property. It's like I said in the reply brief, if you're a tenant at the Empire State Building and they give us a request for proposals for the Chrysler Building, and it doesn't work. There's the complete disconnect
Isn't
of
this more
reality
like a
here.
different floor in the Empire State Building than the Chrysler, than a whole new building, though?
Well, even if it's a different floor, it wouldn't matter because the lease is for this existing property, not some other property, the property where Dakota is. And it has to be that because if Dakota had won in the proposal, it would have the right of uninterrupted use of that property, not some other property, it wouldn't have to move. I mean, it's an oddball settlement agreement, I'll give you that.
Right.
But if you parse it through, take your time and drill down to what's going on here, that's the right that Dakota has. So all you have to do as the airport authority is to have a request for proposals for that lease, and then everybody gets to bid on it, and if Dakota doesn't win the bid, it has to leave. If Dakota wins the bid, it gets to stay. That's what this is all about. I don't know why they did this sleight of hand. I don't understand what the whole purpose of this was. But they did it, and they can't do it. And it's not something that you could resolve in a motion other than in an appropriate motion for summary judgment. But here, that doesn't fit because once you invoke the right to a jury trial, the summary judgment is not an appropriate motion.
But aren't these issues being litigated separately because they're not part of the issue of the right of possession? You're litigating in a separate matter the issue of the settlement agreement and whether it was breached by the other side, correct?
No, there's another issue about the Anti-Head Tax Act. There's another appeal going on.
But that, at least as I read the record, that litigation was related to the enforceability and the violation of the settlement.
Well, yeah, it's important because that's another factor in why this request for proposals is invalid because it's going to continue that Anti-Head Tax Act tax. And so that's another reason why it's invalid. But so those are the two that are going on right now. But even if for some reason the Anti-Head Tax Act appeal does not work out well for my client, they still have the basic problem of the existing lease, existing property, and the settlement agreement. I mean, all this could have been done much simpler, and we'd have been long over with this if the judge had just said, well, yeah, you do have a right to a trial, and let's get the trial done. And unfortunately, we sort of got derailed right at the beginning, and it wasn't.
Why would this be over? It seems like, let's say the jury had come back and found that the alleged claims or your allegations that there was a violation of the settlement agreement don't give rise to a right to continued possession of it,
Well,
and
then-
it kicked you out, would we still be here?
I don't know. You'd have to find a very generous Superior Court judge to say you get to stay in the property while all this is going on. I don't know. I don't know if we'd still be here. I don't think so.
Okay.
But the actual determinations would have been done it took a long time to get the summary judgment motion process finished after all. But the actual determination, the trial would have been over in a week or two, maybe 3 if you asked to extend it under the statutes and rules.
You've only
And-
got
and
a
you're
minute
finished.
40 left if you want to reserve some time for rebuttal.
I want to reserve about an hour, but yes, I would like to stop. Thank
Okay.
you.
I said I wouldn't warn you, but
I'm glad you did. I could barely see you.
all right, counsel for Pelley.
Good morning. Kirsten Murphy with Tony Cullum on behalf of Sedona Oak Creek Airport Authority, which we refer to as SOCA for shorthand. Just very briefly before I launch into my argument, this discussion about whether this is the same property or different property, our position is that it's irrelevant. But just to frame the issue, this is about whether or not we were going to use the existing modular unit or an updated replaced modular unit on the exact same property, same footprint. So it's not a different property. It's just about replacing an old modular unit with a new one. That's what we're talking about here.
Why isn't that a issue of material fact? And I'll tip my hat and say I agree with you that I think that there is a process for summary judgment included in Rule 11. But I do think there has to be no disputed facts. Why isn't that a disputed fact between the parties? They obviously allege it's a wholly separate property and we couldn't have continued to operate there. You guys are claiming, no, it's just an upgrade. Why isn't that something that a jury should decide?
So I think it's an important question to answer. Under the FED statutes and case law, the only relevant question is the right to actual possession. Other extraneous issues, even the more usual and common defenses, are not appropriate in an FED proceeding, which is meant to be a short, plain, speedy summary remedy. And as Judge Cruz asked Dakota's counsel, there is a separate action, a breach of contract and breach of the covenant of good faith and fair dealing action filed by Dakota against SOCA in 2017, litigating these very issues. And their counsel said it multiple times and in multiple pleadings and in this case that the core issues are precisely the same. It's why Dakota sought to stay this FED action from its inception pending resolution of that case. But to answer your more specific question, the right of actual possession is defined by the 2 statutory provisions in this case dealing with forcible detainer. And the only relevant inquiry in a forcible detainer action turns on those 2 provisions. And here, the trial court determined under both 12-1171 subsection 3, but also 1173 subsection 1, that there were no material facts. And if we look at the statute, it's clear to see why. So under 1171, SOCA must demonstrate that Dakota willfully held over lands after termination of the time that it was let to Dakota and after demand was made in writing. The undisputed facts demonstrate that both of those things happened. When did Dakota's lease terminate? The settlement agreement, which was drafted by Dakota, has 2 specific references to Dakota's obligation to terminate. The first is SOCA must issue an RFP, and as Your Honor mentioned, there is no qualifying language. There's nothing about a valid RFP or an RFP of any particular kind. It just says SOCA must issue an RFP. And then the second...
Isn't it implied from some of the other language, like your opposition pointed out, the discussion of the settlement agreement was discussion of their right to continue in an existing property, and so why isn't it implied, if not explicit from the settlement agreement, that the RFP must be for the property that they were occupying?
Well, I guess that what I would answer to that question is that that is not an issue that would be relevant in terms of the right to possession. Even if SOCA erred and breached the contract in issuing this RFP, even if it erred in well, particularly with respect to the RFP, because that's the question, it doesn't give Dakota a right to remain in possession indefinitely in
Did
the property.
Soka lodge, or did Dakota lodge, and maybe this is a question I'll ask Kim in rebuttal as well, but did they lodge any objection to the RFP at the time it was originally issued and said, hey, what are you doing here? This is not what we had agreed to?
Well, it's not an issue that's in the record in this particular case. And so I guess the answer is they probably did. I mean, there have been very few times that Dakota hasn't complained about something Soka has done. But they did submit the RFP, participated in the process, and then were not selected. And so under the settlement agreement, the only triggering event, if you're not successful, which they indisputably were not, they have a 30-day right. I mean, we're here on a month-to-month lease. So talking about 1171.3 is helpful, but looking at 1173 subsection 1 is probably the more pertinent statute. Both apply. But that statute says a tenant from month to month or a lesser period whose tenancy has been terminated retains possession after his tenancy. That's forcible detainer. Or a tenant from month to month after he receives written demand of possession. It's not disputed. Dakota has not disputed. They have admitted in oral argument, in their briefing, et cetera, and the court below acknowledged that Dakota did not dispute notice. Soka made a demand that they vacate the premises on a month-to-month lease that was issued, or that was entered into between the parties in 2017. We're in 2020, 3.5 years later, and they still have employed every tactic, every tool at their disposal, including seeking a preliminary injunction, filing several appeals, claiming all manner of things to preclude Soka from regaining possession of its property when you have a tenant who has been there month to month and received not one, not two, but 5 separate demands to vacate beginning in April.
What if the RFP had been for not, let's say it was more explicit, and I realize you guys are arguing that there's not really a difference in the premises that the RFP was issued for, but let's say the RFP had been not even for occupying those premises, but just been an RFP to provide for cleaning services at the airport. And you said, this is the RFP, and Soka said, well, that's not what we wanted, but applied for it anyway and didn't get it. Would that have terminated their rights under the settlement agreement?
I contend that Soka would have the right under a month-to-month lease to make a demand for return of the property, and that Dakota's remedy at that point would be to do just what it did, which is sue Soka for breach of the contract and pursue a breach of the contract action. In this case, they pursued it and sought a preliminary injunction, which until the Superior Court judge lifted it and the Court of Appeals affirmed that decision, finding that all conditions had been met and that there was no basis for Dakota to remain on the property. That's how it would happen.
Just so I understand your position. Your position is we don't care if the RFP was a sham. We issued an RFP and we awarded the premises to somebody else.
Well, I hate to go on the record and say we don't care if the RFP is a sham, but I would say that the questions about interpreting...
You're saying, what I'm hearing is you're legally saying we don't care if the RFP was a sham.
What I'm saying is that the remedy, that Dakota's remedy for pursuing that argument is not in the FED statutes. Actual possession is defined by the elements set forth in the definition of forcible detainer. If Dakota wants to contend, as it has, that the RFP was a sham, that we're guilty of the violation of the covenant of good faith and fair dealing, which is explicitly in Dakota's appellate briefs in this action, that's an impermissible counterclaim here, but they're not deprived of a remedy. It's just not, this is not the appropriate forum because statutorily this is an expedited process to make this determination. And I want to just touch really quickly on this issue.
Your answer to my question is yes, we don't care. Because this is not the correct forum. You're saying, regardless of whether it was a sham or not, we issued an RFP. We awarded the premises to someone else. Ergo, they're out. And that's the end of the analysis as far as that forcible detainer action.
Yes, I agree with that formulation. I would not say I don't care that it was a sham, but that it's not.
I wouldn't say personally.
Well, or that Soka doesn't care. It's that the law does not permit exploration of those kinds of issues. And let me just frame it up, because what Dakota's counsel below argued was that not only are the issues exactly the same, and that was his terminology, these issues are the same as the issues pending in the breach of contract action, but he said, I demand a 9-day jury trial, 37 witnesses, and 160 exhibits comprising thousands of pages is necessary to resolve the issues in this forcible detainer
The breach
action.
of contract action.
The breach of contract, breach of the covenant of good faith and fair dealing, both. That was the demand in front of the trial court, and the trial court said those are not issues within the scope of the only relevant question, which is who has the right to actual possession, and that question is answered by looking at the language in the two statutes, which says if your tenancy has been terminated and you've received written demand but you refuse to leave, that's 1171, or 1173 if you're month to month and your tenancy has terminated and you've been demanded to leave, or if you've received a written demand to leave, you've got to go or else you're guilty of forcible detainer. The undisputed facts are the RFP issued, Dakota was not successful, SOCA made 5 written demands. Under 1171, that was enough. There were no other relevant questions. If Dakota wants to make an argument that in providing notice, when it did, SOCA breached the contract or breached the covenant of good faith and fair dealing, it has a forum for that, but this is not it. To allow Dakota, to take a short summary proceeding and jam into that a 9-day jury trial on questions where the undisputed facts require judgment in SOCA's favor would just upend the entire FED process. And that's particularly true, again, where you have a month-to-month tenant, and under 1173 subsection 1, all SOCA has to do is make a demand that they vacate. That was done. Obviously, it was delayed because Dakota did pursue its breach of contract action and pursued a preliminary injunction, and the parties litigated that, and once that was resolved, we're here again. And to the extent that there is an objection to the length of time the summary judgment process would take, this issue was resolved relatively quickly. The court set trial for early January, and in about a month's time, the parties briefed and fully presented their position to the Superior Court, and she made a decision very quickly. It did not slow down.
Can you address Dakota's position that even if there are no disputed issues of fact, they are nonetheless entitled to a jury trial?
Certainly. And I think the questions that the court asked this morning are all sort of the issues that I would reiterate, which is, first of all, if the Arizona Constitution has an inviolate right to a jury trial but permits Rule 56 motions, certainly the same is analogous in this particular setting. And in instances where if there is a conflict between a statute and the rule, this court's precedent provides that the court should read a statute and a rule together to harmonize them and give effect to both to the extent that it can. I would note, too, that Dakota's request for a jury trial was made under Rule 11D and Rule 12 and not pursuant to Rule 1176. But every case that I was able to find that has addressed this issue since these rules were adopted in 2008 and implemented in 2009, every case has reached the same conclusion when there's an issue about a motion for summary judgment in the context of an FED proceeding. We cited 2 that were post-2015.
But neither of those did the party challenge the procedure and claim their absolute jury trial, that there was no permissible summary judgment procedure under rule.
I think in those cases there was an acknowledgement of the process, but not particularly a discussion of the...
It wasn't an issue on appeal.
Correct.
Right.
But there are other decisions. We can't cite them because they predate 2015.
I was too young then, so
but there are several other, handful, probably 6, I think, that I found that do take that issue up and reach the same conclusion, suggesting that it is the...
There's no published opinion on this.
That's correct. Although I did, and I apologize that this is late, but you know how research goes, sometimes you find a nugget at the last minute, but there is a 1929 case that, if we're talking about history and the historical background...
That's before I was born.
But that case, it's Brewster Green versus Robinson, and in that case, they do discuss
What's the
that
site for that?
it is 34 Ares 547 at page 552. And in that case, the court says when there is nothing for the jury to pass on, basically, if there is no disputed fact, then it becomes one of law, and it's to be decided by the court. I can't say that the decision turned on that issue. It's an acknowledgement, though, of the historical practice that if there is nothing for a jury to pass on, then the question is one of law. It's not within the province of a jury, and it makes no sense to call and impanel a jury and burden members of the community and the court system to.
Well, based on your theory of we don't care, what facts disputes would a jury be required to consider?
Well, I think that the issue of whether notice was provided, whether there was a written demand, whether the property at issue, the parcel number, for example, was the appropriate parcel number. You could look at things like the.
I could imagine if defendant presented a different lease and said, no, this is the lease that we had signed. And the jury would then be required to figure out which was the actual governing document.
Yes, and I think oftentimes the issues turn on matters of payment, and so disputes about whether and when and how much and those kinds of things with respect to payment of rent, et cetera, might be factual disputes, but I think it's a pretty narrow universe of things that are available to be disputed in light of the fact that the only issue is actual possession.
And because I'm guessing that your position is, and that's why you can have it so quickly, is because there's a limited universe of what the jury can.
Yes, and I think the Old Brothers lumber case specifically gets into that idea that the usual defenses available in civil cases are not appropriate because that's absolutely what happens. It gums up the works. It stops things cold. And as the trial court acknowledged here, not only were these not usual defenses, these were not defenses at all. These are counterclaims. These are arguments that we breached the contract, that SOCA violated the covenant of good faith and fair dealing. All of those things are impermissible under Arizona law. So not only are they not defenses, they are affirmative claims, recast as disputed facts, but that's really what they are. I think I have a minute, if I might just look at my notes to make sure I haven't missed.
I have you with 3 minutes left.
Okay.
But you're not obligated to use them all.
Just want to make sure before I was telling my co-counsel, my 8-year-old told me not to blow it. So just making sure I get it all. I guess I would just reiterate for the court that the lease under which Dakota claimed a right in 2017 expired in April of 2017. The settlement agreement gave them the ability to stay on a month-to-month basis only. It has been 3.5 years. It's longer than Dakota would have been permitted to stay on the airport, even if it had been successful in getting the RFP. That RFP was for a 24-month term. So Dakota has now been on the property. At the time the trial court made the decision, it was 30 months, and now it's something more like 40. So if the FED statutes mean anything, they mean that SOCA is entitled to regain possession of its property immediately, and Dakota should not be permitted to stay another day. Thank you.
Thank you. Mr. Abney, I'm going to ask a question that came to me during her discussion, and we'll start the clock when I'm done asking the question. Did your client, and I was on the panel that decided the last time this case came up, and so I'm admitting I don't remember clearly right now, but did your client, when the RFP was issued, seek to enjoin it? In other words, before the decision was made to award it to the competitor, I can't remember what the name of the competitor is right now.
I believe I believe the client protested the RFP the way it was put together, that it wasn't for the right property.
Okay, so they raised that issue
Yes, Your Honor.
in some form or another?
Yes.
Okay. And then did they actually seek to stop the RFP process and try and halt it before they were unsuccessful?
I don't know if they did an injunction, but they did protest against it, which is pretty much the same thing.
Okay.
This is not the way to do it.
All right. You
And
got a minute
then-
15, whatever you want to talk about.
Oh, then my colleague across the aisle says, well, this is really the very same property, slightly different building or whatever. But, I raised this issue very strongly in the opening brief, pages 21, 30, and 31. And then they addressed that argument on page 30 of the answering brief by not addressing it. They're saying it's irrelevant. And it is relevant, though, because what we're dealing with here is trying to understand what this request for proposal legitimately was going to be about. It's going to be about the existing lease, the existing property. You win the bid, you get to stay with uninterrupted use, and if you don't win, then you have to leave. Unfortunately, this all got bollocksed up right at the beginning. It really should have been, you have a right to a jury trial, let's do it. The judge can certainly control. Judges are very good at controlling how trials are put together. The first step for the judge is actually to determine the factual issues. Okay, then you just tell the parties, these are the factual issues, let's reach an agreement on that. If not, I'm going to tell you what the factual issues are. And then we have the trial. And, you can't bring in the universe of facts and exhibits. You bring in what's relevant. The judge controls everything. The jury hears it, the jury decides, and we're done a long time ago. And that's where everything fell off the rails right at the start. I'd like to give my remaining time to the court to curry favor with you, if I may. And I thank you for your attention. If there's no further questions.
None from me? No, we're all good. Thank you all for your presentations today and your briefs. We will take this matter under advisement and issue a written decision in due course.
Thank you.
Thank you for listening to us. We appreciate it.